Hi, I'm Manny Fitzsimmons. I'm your Washington REALTORS legal hotline lawyer. Welcome back to our video series entitled DB's Wish List. Listing brokers receive offers from buyer brokers with the most extraordinary documents attached. Buyer brokers will often attach Form 17 and the FIRPTA certificate, which shouldn't be attached, but at least they're understandable. Too often we receive offers with buyer agency agreements, the law of agency, an affiliated business disclosure, a home inspector referral disclosure, or other totally irrelevant documents attached. Since all of us are held to the standard of care of lawyers when we prepare purchase agreements, it forces the listing broker to sound very heavy-handed when they ask a buyer broker to prepare a proper offer so that seller can actually accept it. Will you please explain what an offer should and should not include and why? I would love to explain what an offer should and should not include, and also explain how the listing broker in this situation can handle this scenario. I first of all, don't mind a listing broker going back to the buyer broker and saying, look, we've got multiple offers. You need to write your offer properly, and all of this extraneous stuff shouldn't be attached to your offer. So since seller is going to review all of the offers at X time period, you might want to take that time to have your buyer, maybe you don't even have to have your buyer involved. Just send me a copy of your buyer's offer without all the stuff that doesn't belong out of the offer. So, what belongs? This starts from the most basic premise. I want you to think about what a purchase and sale agreement is. A purchase and sale agreement is an agreement between whom? Between buyer and seller. And it's an agreement that sets forth the terms of sale from seller to buyer. Anything that's not an agreement between buyer and seller that sets forth the terms of sale does not belong on the purchase and sale agreement. So what is a Form 17 as an example? A Form 17 is a disclosure form from seller to buyer. It discloses conditions regarding seller's property. Is that a term of sale? Nope. What about the buyer broker's inspector referral form, Form 41D? What is the purpose of that form? It discloses to buyer whether the buyer broker has any relationship to buyer's inspector. Is that a term of agreement between buyer and seller? No. You can go through every single item listed in the question, every other document that you might have an urge to attach to the offer. Go through that analysis. It's really simple. Is it a term of agreement between buyer and seller? If it's not a term of agreement, and if it's not between buyer and seller, then it doesn't belong on the purchase and sale agreement. It doesn't belong on buyer's offer. And buyer brokers, here's where the real problem comes in. If you are dealing with a competent listing broker, and let's assume you are, then your listing broker is going to know and be able to judge immediately whether you are a competent buyer's broker based on the way you've written your offer. And if a seller has 6 different offers to consider, and they're all relatively similar in price and terms, but one of the buyer brokers has done a really good job of documenting the buyer's offer and has evidenced their own competency in the way the offer is drafted, who among all of those buyer brokers do you believe the seller and the listing broker are likely to believe is the most likely buyer broker to be able to close a transaction? The competent buyer broker, right? It's important when you write an offer, buyer brokers, that you not only represent your buyer well for setting forth the terms of the offer that are important to them, but so that you do it in a way to give the seller and the listing broker confidence that you can get the buyer across the finish line. And if you're a buyer broker who attaches all kinds of extraneous stuff to the buyer's offer, and you're dealing with a listing broker who knows what they're doing, then you are going to immediately send off red flag warnings in that listing broker's brain to say, I got a buyer broker here who I'm going to have to shepherd through the process and across the finish line because they don't have a clue what they're doing. It's really important, buyer brokers, that you know how to write an offer, and that starts with knowing how to attach documents. So, are any of those documents that were listed in the question important to get back to seller? Maybe some of them are. The inspector referral form isn't. The seller's own FERPTA certificate probably isn't. I can't remember all the questions that were all the forms that were listed in the question. But the one document that is very often important for the buyer broker to get back to the seller at the same time buyer makes the offer is seller's Form 17. Why? Because seller wants to know that buyer has signed off on one of the 3 signature lines for buyers to start the time clock. If buyer's signing the first signature line, then that's really the one that starts the 3-day time rescission. If buyer signs the second or third, then buyer's already waived their right to terminate based on the Seller's Disclosure Act. But if buyer's signing that first signature line, seller wants that Form 17 back at the time of mutual acceptance so that buyer's 3-day clock can begin to run. So if it's important for buyer broker to deliver the Form 17 back to seller and listing broker, but they can't attach it to the purchase and sale agreement, how do they make that delivery? Buyer brokers, you use 2 different PDFs on one email. You can use 2 different emails if you want to, but that's not necessary. You have a single email. You write, Dear Listing Broker, attached, please find buyer's offer. Also attached, please find seller's Form 17 signed by buyer. 2 different PDFs. No way that the Form 17 can now be confused as being part of the offer. Listing broker doesn't get it and go, I can't believe I'm dealing with a buyer broker who doesn't know that the Form 17 is not supposed to be attached to the purchase and sale agreement. And seller can easily accept your buyer's offer and start down that road towards closing. Okay, that's my rant for buyer brokers. Listing brokers, what do you do when you get the offer that has all of those documents attached to it? Does it really mean that you have to pick up the phone and call the buyer broker and say, sorry, my seller can't accept your offer until you can submit a competent offer? No, it doesn't. Because even though all of those documents are attached to buyer's offer, they come in the same PDF. In some cases, good grief, they're even identified on the blank addenda line on the face of Form 21. Even if they're identified on the blank addenda line, whether they are or they're not, they're in the same PDF attachment. Listing brokers, you need to be savvy enough to know that those documents that aren't an agreement between buyer and seller and don't set forth terms of sale are not part of buyer's offer, even though buyer broker didn't recognize that themselves. And your seller still can accept without modifications buyer's offer. All you need to do is remove those documents that are not properly part of a purchase and sale agreement. So if the FERPTA certificate is attached, the inspector referral form is attached, the Form 17 is attached, any of those documents that are not part of the purchase and sale agreement, remove them before your seller signs the purchase and sale agreement. Then create a new PDF with just the purchase and sale agreement, the addenda, the Exhibit A. Exhibit A, of course, is always part of the purchase and sale agreement. It's actually referenced on the first page of Form 21. So Exhibit A is always part of the purchase and sale agreement. So listing brokers package up your purchase and sale agreement, all of the addenda, the Exhibit A, put it into a separate PDF, send it back to buyer broker and say, congratulations, seller accepted buyer's offer. Please find the fully executed purchase and sale agreement attached to this email. And with that, if both buyer broker and listing broker do all of that, then listing broker, you don't ever have to encounter the poorly drafted or the poorly put together offer. But if you do encounter that, now you know what to do with it. All right, if you have questions on this topic or any other, send an email to me, legalhotline@warealtor.org. Thank you for being a Washington Realtor member.